Fantastic. And Francois, over to you.
Perfect. Thank you, Zelinda. Good morning to everyone, and thank you for joining us for the first webinar of 2026. Um, I believe there's going to be a whole bunch of webinars to come during the year, a lot of exciting stuff to do. So before we start, I'm going to hand over to Kyle just to quickly do our marketing.
Right, thank you. Good morning, everyone. Thank you so much for tuning in for our first webinar this year. Just as Linda said, this webinar will be recorded and published on our YouTube channel as well as our website, and a copy of the recording will be emailed to everyone. And then if you haven't already, please do sign up to our newsletter. This way you can keep in touch with our team. And then just in terms of upcoming events, we will be having our neighborhood live discussion for the year next week, Friday, the 27th at 9 a.m. But please note this feature is for the paid for members only. So if you would need any help upgrading, please reach out to me and I'll be happy to assist. Right, thank you so much.
Perfect. Thank you so much, Kyle. So today we'll be talking about the ABCs of AGMs, or rather annual general meetings. And from the onset, I wanted to state that, AGM is not simply a statutory obligation, it's the primary governance checkpoint of a body corporate. And the success of an AGM is determined long before the meeting convenes, basically. So the preparation is a risk management in a sense. So to cover this topic, we've been joined by two speakers, which I will introduce individually today. The first speaker will talk about meeting preparations, budgets, the role of the chairperson perhaps. And like I said, we'll tend to stick to the ABCs. I know Poena mentioned to me that is going to take it to the A, B, C, D, E, luckily not F. So we'll just stop him if he goes too far. So introducing our first speaker, we have Ruth Grunder. She's the operation manager at PAM Golding Management Services. She assists with day-to-day operations of the business while continuing to administer a portfolio of managing properties. Ruth is passionate about sectional title community schemes and provides in-house staff training for the portfolio managers and property administrators. Ruth has been in the property business for over 20 years, starting as an estate agent, and has been in the property management since 2009 rather. She has successfully completed the UCT Paddock Sectional Title Specialist Realtor course, the UCT Paddocks Sectional Title Schemes Management course, and the Paddocks Home Owners Association Management course, and also completed a LLB through UNISA in 2018. Ruth, that is a mouthful, but I'm going to hand over to you.
That definitely was a mouthful. Thank you for that. Okay. So good morning, everybody. Yeah, I'm very passionate about sectional title. I live it, love it, and dream it. So today we're just going to go through, as Linda said. So I put together something that hopefully will be helpful for everybody. I'm sure all the managing agents in the room know exactly what an agenda looks like. So I just put together the agenda just so that we can sort of work through it to get understand. I then put the actions, obviously for at the AGM, which is how setting it up. Use the MeetingPal app. My goodness me, you can't go to an AGM without them, especially if you've got more than 30 people in a scheme or 40 people in a scheme. Then I have so to load your proxies, to know your quorum, to do your voting, you use the app. It's really, really simple and it works. Then I go through the meeting, but I think I'd rather speak to what the preparation is for the meeting. And then if we've got time afterwards, then I will go through what I call the action items of the meeting, because I don't want to run out of time, because I could talk forever. So you have to shut me up. So the first thing in my book, if I make this bigger, hopefully everyone can see it. We're on the pink column.
I know, Ruth, apologies. I know you've prepared a very nice slide. If you could just present that to us.
Voila! You have to put on share, eh? So we start
another good reason to have MeetingPal at your meetings. They manage the sharing.
I tell you what,
Yeah.
Technology eye. Woo! Okay, as we said, there's the agenda in blue. There's my idea of action items in green, but I'll get back to that. So, good stuff. These things happen. First thing, obviously, set an AGM date. It works for the trustees. I really rather do this as soon as, sort of as early as possible, so you've got enough time, you can plot and plan. Obviously, you know it has to be done within the first 4 months after the year end. But if you leave it too late, I find that it's really, really challenging to get everybody on board. I always try and do it really early so that we have time to plan and we have a goal to work towards. Obviously, then you have to book a venue and the sound equipment. It's all very well having these hybrid meetings. They work very, very well. But if you don't have all the technology that goes with it, it can be all you hear is, I can't hear you, I can't hear you. So we book the venues. A lot of hotels and locals around in Cape Town, they do it. That's fine, but they don't always have the equipment. So we get a sound technician in that plugs in and makes it all work. And then obviously you've got your backup with your MeetingPal people online as well. The first thing is to book the audits, book the auditor in terms of who was appointed at the last AGM. We need the financials, at least the first draft, a couple of weeks before the AGM, so that you can go through them and make sure we're all on the same page. So I always set a date, try and set a date with the auditors when I will get the first draft. That's like top marks. Not always easy, but it's worth trying. Because then it gives you a goal and everyone can work towards. Then obviously you have to prepare your admin budget and have the provisional approval of the trustees. Again, you'll obviously do your work from your previous figures and then you put forward your budget. Then you have to, obviously, you can increase the levies up to 10% until the budget's approved at the AGM. I'm finding sadly our increases are getting a bit higher now because this new council fees have really impacted our budgets. So I don't know where that's taking us. But again, you can only approve the 10% before the AGM, as I'm sure everyone knows, although I'm finding some of the trustees want to wait for the AGM as well, but that's your call. Then we appoint a professional to prepare the maintenance, repair and replacement plan. I don't know about any of you out there. You may be more qualified than I am, but I buy shoes. I don't build buildings. So we outsource that maintenance, repair and replacement plan. There are multiple people that can do it. And then obviously they prepare the concomitant reserve fund budget, which the trustees need to approve. And this is becoming more and more of an issue because we are now 10 years down the line and we should be able to provide this plan with relative ease, but gee whiz, the goalposts change. Suddenly the roof blows off or something else happens. So we do that through the professionals. And then obviously you update your reserve fund budget that the trustees must approve provisionally. Then the nice one is to ask the trustees to prepare their report. I'm not sure how easy you find it. Sometimes it's a bit of a challenge. And sometimes the chairman thinks it's his day in the sun and he prepares it on everybody else's behalf. And the first time the trustees see it is when it's in the meeting pack. If you do it in advance, you've got more chance of input from everybody else. Then hopefully you'll get your draft financials and you can check them and get any corrections done, send them back. Sometimes I only get version 6 to the trustees because there's little niggly bits to iron out before you're happy that, okay, these are the financials you're going to present to the trustees. And then obviously when you update your actual column on your budget, because now you've got your final. So sometimes you go to AGMs and you find that they've only got an estimate or they've only got the year to date 2 months prior to the AGM, to the year end, because they forget to update that actual column. And to me, that's quite important because it puts in perspective the budget you are presenting. If your actual column for the previous year, it reflects true figures and obviously any anomalies that you point out so that your budget makes sense as to why you created it. Then the draft financials go to the trustees for approval and signing. And I also send that updated actual budget for the previous year so they also can see how it all worked out. Obtain 3 audit quotes, that's if required. Some of our members at the AGMs are now asking for a different set of auditors to to be presented for the next AGM. Some body corporates, they just tick the box every year, same auditors. But yeah, so that obviously you would know it's dependent on your scheme. The update of the insurance valuation, if required. Remember, it has to be done every 3 years. So just always make sure you've got the right one to present at the AGM. Well, not necessarily present, but in other words, that your PQ schedule is correct for the AGM. So that some of buildings actually have like a desktop valuation or update every year as well. So it depends what your requirements are, but it's just important that you have the correct valuation so that when you go to the AGM, your PQ schedule, the valuation that you are approving is correct and lines up with your PQ schedules. I have found that sometimes you get the previous year's PQ schedule with this year's insurance document. So just remember to check that so that you don't, or they just haven't changed the heading one way or the other. So just always check that you've got the correct PQ schedule to go in the pack. And again, make sure you have the current insurance policies on hand. I don't send them out in the pack because it just makes the pack too huge. I send out the PQ schedule, but just have the actual current policies ready should somebody ask questions on it. Obviously, you need to know what your current public liability cover is, because that's going to be voted on. And you need to know what the current fidelity cover is and calculate what is required. It may need to go up or down depending on your the figures. Then you need to prepare any special or unanimous resolutions that may be required. Like if you're going to update your rules and stuff, then you have to have all of that ready for the AGM. You have to prepare the proxy form, the nomination form, create a Zoom link for the meeting, put together your AGM pack that must include the following as a minimum. Obviously, if you've got special business, it will have extra. You need a proxy form, you need a nomination form, you need the minutes of the previous AGM, you need the trustees report, your insurance schedule of replacement values, we call it the PQ schedule, the admin budget, the maintenance repair and replacement plan, and the reserve fund budget. The audited financial statements, which have hopefully been signed off and are actually the final set and not a draft. And then any special unanimous resolution that you may have or any other business documents that may be required. We have various things that like to go to AGM, so obviously you'll need all of that in your pack. Then you need to load your MeetingPal app and book a PAL or two if required. If you can load it yourself, great, then you do it yourself. If not, they will also assist you with loading it and send you the invoice accordingly. And they are brilliant to have them on standby at the meeting. They help getting people onto the platform. If you use a Zoom platform, they make sure that the names are correct and link up with your the unit numbers so that you know that you've got the right people in the meeting. And they help with their glitches, because sometimes people seem to wander off and look at the news and then they lose their feed to MeetingPal, and the PAL online gets them back on again. So it's really worthwhile. You need to send out your AGM notice, obviously 14 days before if it's just an ordinary meeting with nothing special on it, or 30 days before the AGM if you've got a special or unanimous resolution on it. In my book, you send multiple reminders regarding the AGM, because a lot of the time if people say it goes into their junk mail, they literally don't receive it, and then you're going to say, yeah, you did get it, it's a bulk mail, check the junk. We send it out on our email system and also through the MeetingPal app, so they get it from both sides, and hopefully one way or the other the notice will go out. There's always one or two that just don't get it. If you're worried about a quorum, we call owners and we ask them to complete a proxy form. You obviously know your own buildings, you know who's who in the zoo, but in my opinion, to run a rerun AGM because there wasn't a quorum is just the absolute worst thing in the whole world. I don't appreciate it. So we really try and push from our side to make sure everyone is going to be there or send a proxy. And I must say, now with the advent of hybrid meetings, we are getting quorums far, far easier than we used to in the past. And people are joining in. We had a big AGM the other night, and there were less people in the room than I've ever seen, and more online. And I mean, the venue was literally across the road from the building. So it's just the way it seems to be going. I found, I don't know about other people. Then 7 days before the AGM, you send out the trustee meeting notice for the trustee meeting that's held directly after the AGM. I like to catch them immediately after the AGM. To me, it's a statutory requirement. It's basically a tick box meeting. You don't have to go through the previous meetings minutes. You can roll those into the next more formal trustees meeting. But I like to hold the first trustee meeting directly after so that we can appoint the chairman, raise the levies now that the budget's been approved, and do all those little things that you need to do after the AGM. Then that's done and dusted, and off you go. I track all proxies received, make sure that they're signed by the relevant party. Especially remember that if it's a couple giving A or B their proxy, it needs to be signed by all parties. If it's a company or whatever, that's a representative, then you need the documents giving the resolution document saying, yes, A can represent company XYZ. And all of those things you need to have on file. I just chuck them in my meeting folder, then I've got it should anybody ask. And the ask they do, I'm having a lot of people, I want to see it. I want to see the proxy. I want to see the resolution. I don't know about you, but we're finding people are sort of almost wanting to do a forensic after the AGM. Yeah, it's just a new world out there. Yeah, and then good luck. You should be good to go. I don't know how much time I've got, Zelinda, have I got, or Francoa, have I got more time to go through the other column?
You can definitely have another couple of minutes, Ruth.
Yes.
It's just I just had some comments on actually running the meeting once you've done all this homework. To me, I don't know, I find the meetings that I'm the most nervous for seem to work out the best. The ones that I think are going to be easy can explode in your face. So yeah, so there I've just put some sort of actions next to the various things on the agenda. Again, set the date early, use your MeetingPal app. Be prepared for this one. Every now and again, the chairman decides he actually is not going to attend the meeting, and that can make chaos when who do you appoint. So 90% of the time the chairman is there, then I always just say we'll facilitate it. So I always say I've got a big mouth, I'll facilitate it. I'm not the chairman. I have opinions, but I can't vote or make a decision. Then the notice is the MeetingPal provides proof that the notice was sent. So if anyone wants to query it, that setup does provide proof, and the proof is the pudding, they're present. The proof the agenda, I try and stick to the standard items and note any additions at the end. So like, it's easy to approve. This is the standard agenda. It's come straight out of the act. Let's just move along swiftly. And that's generally the first time we test the MeetingPal app. So that one can take the longest. Hopefully you have your chairman, so you don't have to vote on that one. But when you approve the agenda, that one, then you have all your little, I can't do it, I can't understand it. Get that all sorted out, and then your meeting flies because everyone knows what they're up to. The confirmation of the previous minutes, that shouldn't be an issue. They were circulated after the previous AGM within the 7 days, and they were sent out in the agenda pack. So I've not personally had issues with approving previous minutes. Again, there shouldn't be any unfinished business. The new issues would be dealt with under point 21 of the agenda. With a bit of luck, you managed to get through the previous unfinished. Trustees report, make sure it's done timelessly. Then you can just take it as read. You don't have to go through it at the AGM, in my opinion. I can say I've got lots of opinions. You don't always have to agree with them. Prove the valuation. Obviously, you've done your valuation. That gets approved. And just remember to advise owners that if they want to increase the sum insured of their particular unit, then they can do so. Obviously, the cost would be for their account. Know what the cover is for your public liability. It can't be less than 10 million. We've got crazy figures these days now, up to 150 million. I mean, it used to be 50 million top. Now it's more 150 million. Know what the current cover is with your fidelity and calculate what's required. And then, as you know, they can vote for more, but they can't vote for less. That's additional business. That's additional cover. I very seldom to never have that. If that was required, you'd need to give 30 days notice for the special resolution. Yeah, make sure you know what has, I've got typos in there. What is being presented, that you have the actual amounts of the previous year. As I explained, they must balance with the financials. Again, an up-to-date plan. I've seen plans that are like 5 years up to date because I think there's a general misunderstanding of what's required. But the more up-to-date and the more relevant stuff is, it's easier to manage your scheme because you know what's coming towards you. That's in a perfect world. I know it's not always easy to get that. And the reserve fund budget, I've started including a summary for the current year because it makes members, it's easier to understand, because there's been a lot of misunderstanding with that 10-year budget. They look at it, they go, oh my gosh, no, what is this? And they look at all the stuff where you say that you're actually accruing funds for a big project. So I do a simple, this year, this is what we're doing, like a summary sheet, which helps get it passed. Yeah, should be a signed set and taken as considered. It's not the audited financials. I don't really need to believe they need to be discussed. Should somebody have a question, obviously you would go through it. Again, the audit shouldn't be a contentious issue unless you've been asked to get quotes. Determination of the number. Yeah, just ensure sometimes your rules require X and Y numbers, so just make sure that it's not, is it an owner decision or is it a rule decision before you take that to the vote. And I always believe less is more, otherwise it gets really difficult when you're trying to manage a whole lot of trustees. No, trustee nomination should be in 48 hours in advance, and sometimes that's it. If you don't get nominations, you don't get trustees. So yeah, that can be quite challenging at the moment. I'm finding it challenging at the moment to get trustees. So if you decide on 3 is your number and you have 3 nominations, well then those are your trustees. And people are really not keen on being trustees at the moment, I found. Okay, any lodgement of scheme rules, obviously you know your situation. Are you waiting for a CSOS certificate or has nothing changed? So you just need to update the owners there. The restrictions or directions. Sure, this is an interesting one. Different schemes seem to have different opinions as what should be there. Obviously, you would have an idea of what your schemes required in the past and what they want going forward. I've got directions like must be at least 1 month's notice for a special levy. I've got directions where all the trustee meeting minutes must be sent out. Invitations to trustee meetings must be sent out. I've got limits of what you can do if you have an unbudgeted expense of more than 150,000, then you must advise owners. I mean, if the lift breaks down and you didn't have a budget for it and you need to fix it, obviously you're going to spend that money. You need to advise owners. Other schemes, they say, no, the owners want to vote on it. So you know what, that's different in each scheme. The confirmation of the domicilium, that's probably a repeat of the last year. It will be your address or whatever is on the thing. Deal with new or further business. Good luck with that. It can get fun, as I'm sure you all know. And then for closure, I always just thank the trustees and close the meeting, because most members forget to thank the trustees for their unpaid slaves job of the year before. Yeah, so that's me on meetings in a nutshell.
Perfect. Thank you so much, Ruth. It was a mouthful and very exciting stuff. I think it's a good indication of what you need to do before entering, the annual general meeting. And you've touched on a few important points, especially, points I wanted to touch on is often we see in practice that, a trustee who represents a trust, for example, does not necessarily have the required or valid, legally required resolutions to vote, perhaps, which may influence the quorum, for example. And another thing is the resolutions to be included into the pack sent out to members, especially when there's an important decision to be taken, like the change of rules and everything associated to important decisions. And that all leads, and it must be, noted in the minutes of the meeting, obviously, what the outcome on the voting of those items are. And who better to speak to with regards to keeping of minutes than Poena Leroux. So those of you who do not know Poena is an IT professional with approximately 35 years of experience. He has been actively involved in sectional title management for over 20 years, serving as an owner, a trustee, and chairperson for a 50-unit self-managed complex. Poena holds an MBA from Bond University in Australia and has completed various paddocks courses. He is the founder of a software development company established in 1992, which initially specialized in insurance and banking systems. The company has since evolved to streamline community schemes management. In 2017, Poena designed MeetingPal to facilitate voting based on number and value votes. Despite initial skepticism about the need for an e-voting application, he persevered. During the lockdown in April 2020, Poena led his team to develop MeetingPal, ensuring that it enabled compliant remote meetings. Since its launched in August 2020, MeetingPal has been adopted by thousands of bodies, corporates, homeowners associations, pension fund administration, and companies, facilitating thousands of meetings. The application is gradually expanding into the international market due to hybrid meetings like Ruth just informed us. I can't even remember when a AGM was held in person at a venue, paid for by the body corporate and so forth. So I believe that this is essentially the future. So Poena, if you can, please inform us about keeping of minutes at the meeting and MeetingPal.
Good morning, everybody. Thank you. And Ruth, thank you for all the mentioning of MeetingPal. I do appreciate that. From a MeetingPal point of view, we do quite often get involved or tasked to also draft minutes. And as the packs are also loaded onto MeetingPal, we have insight into how minutes are drafted. I mentioned to Ruth yesterday that we are quite often seeing minutes being drafted, and you can see, and I say this respect, a lot of managing agents still go, any objections? Because you can just see minutes was approved. So there's no yes or no calculations. It literally just was approved and so we can actually pick up quite readily when they're still following the old process, if I can put it that way. And then in terms of the minutes, there are quite a difference in opinion. And again, back to what Ruth was saying, is once you know and understand your block or your scheme, you understand what the culture, and I call it the culture or the ethos of the company or the community is. Because some like it in nth degree of detail. Jan said, and he was upset about that, and those with a bit of a military background comes through. This was discussed. Thank you. Let's that kind of approach. So it depends literally on the ethos of the body corporate. With that in mind, I've in the past drafted an ABC of minutes, but to the point that was made earlier when we did prep for this, I've extended it a bit. The blog was written and posted on the TVDM website 2-3 years ago or more. And typically, what we've done in the past is that we've extended it to include ABCDE of minutes. So the A stands for accurate. So it's got to be accurate. So whether you go for a lengthy 200-page minutes or just the 2-page minutes, literally everything needs to be accurate, and you must be able to substantiate what you're saying there. Then it's got to be brief. In my mind, again, there are items in terms of the act, what you need to follow up on. I do not believe that it should include Jan, and there was a discussion and was mentioned, and this and that, and then 2 people commented on, and so I don't believe that all the essence of that should be there. Now, the understanding is that from a governance point of view, and this is where I'm venturing into a grey area, is the recording. I believe that the recording should be there for those detailed discussions. If we do get challenged, we can then go back into that. But and I'll just touch on the recording in a minute. But it's got to be brief. It's got to be clear. So there must be, and for ons Afrikaans, I mean the consistent tense. The past tense and past present, whatever tenses. We just got to go with one kind of tense and then work in that mode. So it's important to, when you draft the minutes, to be concise in terms and clear in terms of the approach. And then also remove any inflammatory, any bad language. We do have that, and it's got to be clear in terms of what was the intention and what was the discussion and what was the outcome. So that is the principle. And then what we've added subsequently is defensible. Because we're getting into a lot of cases being called into CSOS and whatever, so you got to ensure that if there's a scrutiny from the auditors, and I can warn you, whenever there's a palace revolution, old trustees get removed, new trustees come in, you got to be able to defend your result, defend your minutes, defend the calling of the meeting, everything. So you got to make sure that you have all your ducks in a row, and that you can actually defend the position that you're minuting in that regard. And then lastly, I believe it should be evidence-based. So in terms of process, you got to have it available at the drop of a hat. Now, what we quite often find is using Teams and Zoom and SharePoint and lots of very intricate electronic storage medias, and if there's no standard set within the company where you need to store stuff, it gets stored all over the show. And then 2 years down the line, I'm going to ask a question. It's a mad rush trying to find the recording, first of all, because you did it on Zoom or Teams. On Teams, it expires after 30 days. Zoom, you've got to download it, otherwise it expires as well. And so you've got to then find that. And if you've not downloaded it and stored it in a central place where everybody can access it, you can forget it. You're not going to get access to it. The same happens for your proxies, the copies of the proxy. You've got to store it and make sure that if somebody challenges you, you've got to be able to pull up the evidence, your proxies, your resolutions. Everything needs to be in one central place. So that is just our understanding, well, our approach to it. We believe, and perhaps it's because I'm a very lazy person, I like to make sure that I have it in one area, and then whenever there's a query, we can literally just do one click, go in there and pick it up. The use of AI is becoming more important, and it's a great tool, especially in terms of tedious administrative tasks like taking minutes. The only word of advice that I can give you is just don't do the AI and don't even read through it. We can actually see a lot of these AI generated resolutions and or minutes coming into meetings where if you on the face of it, it sounds perfect, but the moment you go into what does this mean? I don't know. That's what AI gave me. So there's no comprehension in terms of the process. So if you are using AI, again, the prompt engineering, you need to ensure that you understand the prompt engineering. So those are the ABCDEs of minutes that we believe in, and that we as a team on our pals we apply to that. Also, one thing that I do find, and I'll just give an example, is we make an assumption in our minutes that people understand what we're presenting to them. And I'm of the opposite opinion. I say that the assumption I make is that everybody's like me. You got to be able to tell them exactly what they're reading. So in my minutes, I always like to include a summary of the resolutions. What was the resolutions? What was the outcome? And the detail to that. Because even if you give it to them within the minutes, people don't read the minutes. They don't know the budget carried and. So I just prefer to have it in one place and saying, this is some of the resolutions we've done. They passed, they failed, whatever. So we have a record of that. So that is my approach to minutes in terms of that. Now within MeetingPal, if you just allow me a second, what we do is all our meeting notes, we capture the copies of the manual voting cards, the proxies received, the resolutions received, everything. We capture that and we add that as meeting notes. Again, when anybody asks me something, I just pop into my meeting notes. I can see what was asked. I can also download all my meeting chats, the questions and answers. Everything is in one place. So that if anybody then wants to have it, it's there. Now, this is a test site, so you can see we've done many, many recordings in this. But the principle behind this is in the meeting, we get challenged. Why did we adjourn? Did we not have a quorum? Or what was the matters discussed? And a lot of chairs like to set up the time while they are waiting for the quorum to be achieved to discuss things just overall and in a general fashion, no specific voting and or in terms of the meeting structure of the meeting. But then they would ask us, okay, so we to record it, where can we find that? And we owners want to know. So for us, it's important to have all our recordings in one space and then all our transcriptions also in one place. Now, the transcriptions we use that to generate our minutes within MeetingPal. So within MeetingPal, we have the ability to generate the minutes. We can generate that through a ChatGPT, a type of function. We've built our own PAL GPT where we then take the transcriptions, all the outcomes of the meeting. This is an HRA. Let me just give you an example of a more detailed one for a sectional title. So we can then within that identify whether the resolution passed and whatever. So the wording that we are using is when we draft our minutes, it's resolved that the minutes of the AGM be approved. Here's the outcome. We can see how many have abstained. Sorry, because a lot of people, even though it's a yes, no, they would like to know who abstained. Apologies for that. I had a bit of a flu over the weekend, but I'm recovering. So in terms of the process, this is what we will to build in within MeetingPal, and then we can download it as a doc. A Word doc, we can change it, and then we can email it to owners.
Sorry, Poena, could I interrupt just for 1 second? Just on that abstain issue, I mean, you guys know my view on it, and we had an interesting discussion a couple of years ago with Willie from Stratifen. The recording is on our website as well. That in a sectional title scheme, there is no longer abstain, and abstentions in terms of the common law of meetings. And interestingly, the Sectional Title Schemes Management Act says that when something relating to meetings is not dealt with under the Act, the common law of meetings applies. A very little good handbook to have is the Common Law of Meetings by Paddocks. You can get that and keep it with you when you go to meetings. But it says that when you allow abstentions, that actually decreases the quorum in terms of which the votes are calculated, which is quite a dangerous situation to be in. But we do find, and Poena always has to be on his toes because so many different types of schemes appoint MeetingPal. HOAs, retirement schemes, body corporates, mixed use, all sorts of weird and wonderful things. A lot of other types of community schemes allow abstentions. Where this functionality in bodies corporates really is very useful, Nicole and Sarah and Francoa will agree, is where you're trying to get a resolution passed, knowing that you're not going to get the required percentage and then needing to make an application at the Community Scheme Ombud Service. You'll know then that the CSOS wants to know who voted, who didn't vote, who voted no, why did they vote no, and all of those fun things. And all of that can be then built into the platform. Sorry for that, Poena. My apologies for interrupting you.
No, you saved me. You just gave me some time to catch my breath. Thanks, Lynn. No, you're right. We do have the option, and again, even within that, we have very, very big managing agents that when they set up their meetings, even that, we allow you to set up. How do you calculate and account for abstentions? Whether you want to add an abstention button and because you won't believe it, that some of them are actually insisting on that and that it should be there. And even the calculation of a special resolution in number and value, sometimes they only want to use that against those the voter. To your point earlier on, do you then drop them from the quorum or not? So I have my ideas, but you know, we've come to know that I'm not the most clever guy on the block. There's lots of opinions out there. So we do cater for all of that. But to your point, it depends. So the advantage that we have is, irrespective of how you want to display the results, the votes in the calculation, the votes are captured, and there's an order trail about who voted what. It's merely then just a presentation layer that you then have, and that will then affect your minutes in that regard. So I don't want to sell on MeetingPal. It's more on having in our minds the ABC DEs of meetings to ensure that whatever you present in the minutes, and when we get into the approval of the minutes, I always make sure when I chair the meetings to ensure that people understand this is about factually, when you approve the minutes, it's about factually correct statements in the minutes. It's not about me being an Afrikaans ook and going, I are so glad. You know, that is the principle that not in terms of grammar and or spelling mistakes, because a lot of people get totally tied up and held up in terms of, no, but you used this term incorrectly. Is it factually correct? Did we miss? Should it be 10,000 or 100,000? You know, those kind of matters. So that is of the, you know, the accurate brief, the clear, defensible, and evidence base in terms of process. Just make sure that whenever you draft the minutes, whether it's got to be down to very, very detail, or just a summary, if you look in terms of the essence of what was discussed. With, in my mind, because we also keep all the recordings centrally in MeetingPal, that it is in one area that if anybody challenges that, and let me just then address the recordings, most and all the managing agents that we're working with, or portfolio managers, and even chairs, professional chairs from the outside, always states up front that the recording is there to for minute purposes. It's not there to be distributed to everybody. And that then allows you then to drive that principle. Now, also something that you then, and Zelinda also alluded to it when we started the meeting, a lot of people on Zoom and Teams brings in their own AI readers, and it becomes a mess. You can't tie it up to your minutes. You can't tie it up to your attendance register. MeetingPal, our built-in video caller, do not allow any AIs to join the meeting. We are the AI, and we then control the meeting and make sure that when whoever joins the meeting are then validated in the attendance register against the owners list, the registered owners list, so that the two gel and match up. That's from my side.
Thank you so much, Poena. I think when you mention the use of AI in any profession, you know, people start to listen, and you know, it certainly helps us Afrikaans oaks with the tenses and stuff. That you know, we Afrikaans oaks, we have a English data bundle that usually expires at 4 o'clock in the afternoon. So yeah, minutes has to be accurate and correctly filed for future disputes, or you know, whatever the case may be. So thank you for sharing that. I would now like to move on and open the floor for any questions.
We've got a question on the chat from Keith. He says an owner resides in a sectional title scheme and owns 2 sections. He gives a proxy to the tenant residing in one of the 2 sections. Does the owner's presence in the AGM not invalidate, suspend the proxy, and can the proxy be asked to leave the meeting? So there's 2 questions there. One is a bit of a trick one. Ruth, do you want to tackle that one for us?
Okay. Yeah, that is an interesting one, because it depends on how he owns the 2 sections. If it's in his name A, then you can only get the proxy for both sections. You can't split it in half. So it depends which way it falls. And yeah, I often have that they give the proxy to the lawyer, but they rock up as well. I like to throw them out if they're not supposed to be there. But if you have both the lawyer and the owner or whatever, then it's like who's holding the proxy, who's actually attending. Then only that person can speak. So that's the way I handle it. Yeah, if it's only the tenant, they generally have a lot to say. They're living there and they can actually be quite useful because they know what's going on the ground. So yeah, it depends. I always check with the chairman, which way do they want to go. 90% of them say it's fine, they can both be there, but only one talks and votes. So that's how we deal with it.
Perfect, thanks so much. I'll draw your attention to the chat, ladies and gents. I've added in 2 links there. The one is the webinar recording with Philly and SHP, now HP attorneys, about the abstentions, and the other one is a very good article that Poena did for us quite a while ago, the ABCs of taking minutes. So we just played on that ABC again, hey? We've got another question. I think, Francoa, this is a goodie for you, not from our sectional title perspective, but at least for F. Willemse attorneys. For those of you that don't know, Francoa ook van Pretoria af, selfde as Poena, also has a practicing law firm where he specializes in estates. So I know you know a couple of things about trust as well. The question is from Karen: what documentation is required to form, what documentation is required from a property held in a trust? I understood it as to form a property in trust, but it is what document is required from a property held in a trust for a meeting.
Yeah, so thank you, Zerlinda. I see another question just came in from Sharon, so I'm gonna, attempt to answer both in one answer. So the required documentation for one representative to attend the meeting, or the special general meeting or annual general meeting, will in essence be your proxy form, according to the SDSMA and the rules of the body corporate. But the required documentation that representative needs is a written resolution from all the trustees in the trust where the property is held. So only when you got the required resolution are you entitled to make decisions on behalf of the trustees and the trust. So yeah, it's similar to getting a letter of executorship, for example. That letter of executorship does not necessarily appoint you as Francoa to act on behalf of a company, or to attend meetings and so forth. It essentially entitles and authorizes the appointed executor to appoint another agent, for example, like F. Willemse attorneys. Then with that special power of attorney, and I know we've discussed this in length, whether a special power of attorney constitutes a proxy, which in my opinion it does not. So yeah, that's basically it. I hope that answers the question.
Perfect. I think you stole Nicole Snell's thunder over there because she wanted to open up that can of worms about the power of attorney. No? Okay, good. There's a follow-up question from Sharon. Is this an annual requirement? So as far as I know, for a power of attorney, it obviously needs to say in the power of attorney, special or general, when the period is for. And for a proxy, remember, you must use the prescribed proxy form, and on the prescribed proxy form, you can actually say for this meeting or all meetings before a certain date. So you can make it an open proxy or not. What I have found often, and this is just a little reminder to my managing agent colleagues, is that really take focus on when you're reviewing a proxy form, because if the owner has given that proxy holder an open ticket to attend meetings for all meetings or meetings till a certain date, make sure that you keep that proxy on record, not only for that meeting, but for future meetings. Because if you go to a meeting and somebody says, oh no, my owner gave a proxy form in 5 years ago that allows me to attend all the meetings until 2050, it is your obligation to have kept that. The person doesn't have to come again to the meeting with the form the whole time. The same with the power of attorney. Once it has been submitted to the body corporate, it is the body corporate, the managing agent's responsibility to ensure that they've got that on record for all meetings until the expiration or the withdrawal of the power of attorney, not just for a particular meeting. I've fallen into this trap myself when I was a managing agent. You can't turn around and say, oh, well, just give it to me again. Once it has been sent, that person has done what they needed to do. It's then on the body corporate. Poena, you've got your hand raised.
Thank you. I also posted the question in the chat there. One thing that we do quite often find is that they would give a proxy, and then when the meeting adjourned due to no quorum, in the next meeting, the actual meeting then 7 days later, proxies are disallowed. The meeting did not take place. Effectively, the principle is that it is for this meeting. The fact that we did not have a quorum then would bring us into that state. So that is an interesting one. And I don't know, that's my view is that it is for the meeting. So, I mean, perhaps you can just qualify and or clarify that.
So again, the proxy form is prescribed and it does provide for the adjournment. What I often find is that the owner at an adjournment is sometimes able to attend and then would need to withdraw that proxy that they've given, or perhaps even the proxy holder is not able to attend. So again, Ruth mentioned when attorneys attend meetings, we attend meetings often, and sometimes I do prefer my client to be there because they can participate, they can whisper in my ear if necessary. Obviously, I can't have full instructions for every meeting we attend, but very often we are not available that following week. So then, perhaps I'm not available, Nicole has to go, or Nicole's not available, Sarah has to go, or Francoa has to go, whatever it might be. So very important to just make sure that the position that you thought was for a particular meeting is the same for a meeting a week later. I actually got a question from a managing agent colleague yesterday as to whether or not an adjourned meeting still takes place 1 week later, same day, same venue, but if it could take place an hour or two later. And I said, no, it's same date, same time, same venue. An argument can be raised when it comes to venue that maybe the physical venue is not available and then the meeting is going to be held online as to whether or not that will require a fresh notice. We also had a matter not too long ago where the owners weren't able to take a decision and they said, okay, we're going to adjourn for a week. You can't adjourn for any other reason other than a quorum. If you need to stand the meeting down because maybe there's an upset owner that needs to be spoken to or something along those lines, that's fine. And then if the chairperson says that, order is not being maintained and the meeting needs to be called off, a fresh notice needs to be sent. So it's interesting, and this happens quite a bit in the sectional title legislation, where the legal interpretation under the Sectional Title Schemes Management Act is very different to the English definition of it. Unanimous is another good example. A unanimous resolution is 100% of an 80% quorum, not 100% of all owners, like the word unanimous means. So it's a bit of a fight between sectional title versus English. Are there any questions from the floor? I don't see any more on the chat. We've got a couple of minutes left. Well, I take it that everybody is experts AGM planners. I see one question came in, quite a long one. Let's see what we can tackle here. Trustee boundaries. Could you please clarify what practical remedies are available to members where trustees appear to act outside of the STSMA? I think we're going to skip that one, other than where it says in terms of restrictions and directives. So remember, the trustees are only able to act in terms of the Act, the rules, and any directives and restrictions placed on them. If there's any loss or any damages that is experienced, you would take legal action against the trustees in their personal capacity. Then we've got one, perhaps Ruth, you could answer it for us, nomination and voting concerns. How should members approach the nomination and election of trustees where there are existing governance concerns or active CSOS matters involving current trustees in terms of nominating same?
It sounds like a hot potato. And people always say that they don't know the trustees and they don't know who's been nominated. But you've got to apply your mind when you nominate somebody, and then the meeting will decide who's nominated. Unless there's reasons why trustees can't be a trustee, unless they fall into those categories, they can be nominated, and then the members decide at the meeting. And yeah, we have a lot of this. Our last meeting, we tried to put on the nomination form, please send a short CV so that we could sort of introduce you to the members. And they wanted it sent out 7 days before the meeting. Or you didn't even get nominations 7 days before the meeting. So it is a challenge, and a challenge to not run people down or badmouth them or whatever, but people have different opinions about people. Yeah, it's democracy. You vote them in or vote them out.
And sometimes play a bit dirty. Hey, Poena?
I just want to add on to quite often where we get involved, where owners have called the meeting to remove the trustees. Then they themselves don't nominate themselves and the trustees, they just get voted off. They're the only ones nominating themselves and they come back on. And then it's like, no, they can't. There's no rule that prohibits them or excludes them from being trustees again.
It happens so often, hey? Gee whiskers. It's all about strategy. A lot of these meeting preparations is all about strategy, determining what the number of trustees are, looking at who is making themselves available, speaking about who might become available, very much about strategy. There's one last question that we're going to take. We've got 1 minute left. Under what conditions, reasons can a trustee nomination be declined? So obviously, the trustees cannot decline a nomination, nor can the managing agent. The members can most certainly vote against a potential nominee, but there are grounds for disqualification as a trustee, and that it is very similar to the grounds under the Companies Act. If they're a little bit cuckoo, they cannot be a trustee, but they have to be declared cuckoo, of course. If they have been convicted of an offence, Nicole thought that was a funny one, the trustees can be if they've been accused and convicted of a crime involving theft or a breach of trust. That's just some of the examples. If they're insolvent, thank you, Nicole, for whispering in my ear. Yeah, for those of you that don't know, I'm busy working at Nicole's house today, so she keeps on talking to me when I'm trying to listen and adding her 2 cents in. Yeah, so those are the bases under which the trustee nominations can be voted against. Also, just one more thing from me, and this is more of a practical thing than anything else. When you are at a meeting and the number of trustees that is available, in other words, the positions are available and the number of nominees are the same, there is no need to go to an election. So you don't vote against anybody and you don't vote for, and only those that get a majority become trustees. If you've got 5 vacancies, 5 nominations, those 5 are going to be trustees. If you've got 5 vacancies, 12 nominations, you have to obviously go to a vote. And I still go to meetings and I shudder and I shake my head where the calculation is done on how many votes were received. It's not how many votes were received, it is the participation quota, because the items of business at an annual general meeting are ordinary resolutions, and ordinary resolutions are calculated only in participation quota. Not there's 12 of us and 11 of us have voted, not who has voted for and who has voted against. Participation quota only. When it comes to special and unanimous resolutions, that's participation quota as well as in number. And then one last thing, and then I promise you I'll shut up. When you vote in number and you own multiple sections like Ruth mentioned, you are 1 vote in number only, and your total participation quota will count. So those are some intricacies I find in the Sectional Title Schemes Management Act. Ruth, Poena, thank you so much. I'll hand over to Francoa to close the session for us, and then we look forward to seeing you next month. Just a reminder that if you'd like any assistance, any demos, have any questions about our neighborhood, please don't hesitate to reach out. You can reach out to any one of us or to Kyle directly, info@tvdmconsultants.com, and we will gladly take of our time to take you through our neighborhood experience. And for those of you that are our neighborhood members, thank you for participating in the session today. Over to you, Francoa.
Thank you, Linda, and thank you for you all joining us this morning. We'll hope to see you very, very soon. Okay.
Great
Thank you
stuff.
so much. Thank you.